You're all welcome to today's news analysis. This is not noise. This is not rumor. This is serious African human rights business. If you're Nigerian, you need to hear this till the end. A powerful human rights group based in Africa has stepped into the Nnamdi Kanu case. Not online activists. Not politicians. A real legal body with power. Before we go deep, please subscribe, turn on your notifications, and stay with me. This story is heavy, and it affects Nigeria's image, justice system, and future. Let's get into it. The Institute for Human Rights and Development in Africa, also known as Ihrda, is based in Banjul, the Gambia. This is not a small NGO. This is one of the most respected human rights legal bodies in Africa. They fight human rights cases across the continent. They go to African courts. They challenge governments. And they don't play politics. Now, this same Ihrda has turned its full attention to Nigeria. Specifically, to the Nnamdi Kanu case. This move alone changes the weight of the conversation. When an organization like Ihrda steps in, it means the issue has crossed local boundaries. It means the matter is no longer treated as internal politics or domestic disagreement. It becomes a continental legal concern. That is the level this case has reached. Ihrda is known for providing free legal help to victims of human rights abuse. They do not work for governments. They do not answer to political parties. Their loyalty is to African human rights law and the African people. Over the years, they have taken bold cases before African regional courts and panels, and many governments have had to respond because of their work. So when Ihrda looks at a case, they do so with legal discipline. They study court records. They review procedures. They examine whether the law was followed step by step. They do not rely on public emotion or media noise. Their conclusions are based on documents, timelines, and legal standards recognized across Africa. In this situation, their focus is clear. They are examining how the Nnamdi Kanu case was handled from the beginning. They are asking whether the process met African human rights standards. They are asking whether the court acted within the limits of the law. And they are asking whether the final outcome reflects justice or legal failure. This is important because African human rights law exists to protect individuals, even when they are unpopular, controversial, or politically sensitive. That protection is not optional. It is a legal obligation that countries agree to when they sign regional treaties and charters. Nigeria is one of those countries. Nigeria has committed itself to these standards. That means Nigeria's courts, prosecutors, and judges are expected to operate within those limits. When questions arise about whether those limits were crossed, organizations like Ihrda are mandated to step in. What makes this moment serious is that Ihrda is not issuing casual comments. Their involvement signals that they see potential violations that deserve deeper investigation. They are not speculating. They are working through legal channels. And once they begin, the process does not stop easily. Their interest in the Nnamdi Kanu case also reflects a broader concern about the use of courts in politically sensitive matters. Across Africa, human rights bodies pay close attention to cases where criminal law, national security, and political expression intersect. These are areas where abuse often occurs, and where legal shortcuts can have lasting consequences. By focusing on this case, Ihrda is effectively asking Nigeria to demonstrate that its justice system can withstand international legal scrutiny. This is not an attack. It is a test. A test of procedure, fairness, and respect for the rule of law. Another key point is location. Ihrda is based outside Nigeria, which gives their work added credibility. They are not operating under local pressure. They are not influenced by Nigerian politics or public opinion. Their distance allows them to approach the case with independence and calm judgment. As they continue their review, they are gathering facts, comparing actions against African legal standards, and identifying areas where the process may have failed. This includes how the trial was conducted, how decisions were reached, and whether the rights of the accused were fully respected throughout. The moment an African human rights body identifies possible errors, the matter gains momentum. It attracts attention from legal communities, regional institutions, and international observers. Governments are expected to respond, clarify, or correct. That is why this development matters. It marks a shift from debate to legal examination, from opinions to documented review, from local outrage to continental accountability. Nigeria now finds itself under the lens of African human rights law, not because of social media pressure, but because a recognized legal institution believes the case deserves that level of attention. This is the foundation of everything that follows. It sets the stage for formal engagement, legal correspondence, and possible actions within African legal mechanisms, all of which operate on rules, evidence, and precedent rather than sentiment or political loyalty. Once this stage is reached, outcomes depend on law alone. This is why the first step taken by Ihrda carries long-term weight for Nigeria and cannot be ignored lightly. Now attention shifts to what Ihrda says it has found so far. This is where the issue becomes more serious, because the focus is no longer on public opinion but on legal process. According to their ongoing review, the concern is not only about the final judgment, but about how the entire case was handled inside the court. At the center of this review is the trial process that led to the life imprisonment sentence. Ihrda is examining whether the proceedings followed basic principles of fairness required under African human rights law. These principles are clear. Every accused person has the right to a fair hearing, a competent court, and a process free from legal shortcuts. When any of these are compromised, the outcome becomes questionable. One of the key issues raised relates to how jurisdiction was applied. Under African and international human rights standards, courts must operate strictly within their legal authority. If a court proceeds in a manner that stretches or misapplies its jurisdiction, that becomes a serious legal problem. Ihrda is assessing whether the court handling the case acted fully within those limits. Another issue under review is procedural consistency. In law, consistency matters. The same rules applied to one defendant must be applied to another. Deviations must be justified clearly and legally. Ihrda is questioning whether certain procedural decisions in this case met that requirement or whether exceptions were made without strong legal grounding. There is also concern about how the charges were managed throughout the proceedings. Human rights law demands clarity and stability in criminal charges. Changes, amendments, or expansions must follow strict rules. Any confusion or irregular handling of charges can affect the fairness of a trial. This is one area Ihrda is closely studying. The role of the presiding judge, Justice Omotosho, is also under scrutiny. This is not about personal attack. In legal review, judges' decisions are examined based on records, rulings, and adherence to law. Ihrda is analyzing whether judicial discretion was exercised properly or whether critical errors occurred during the process. Errors in legal proceedings do not always involve intent. Sometimes they result from pressure, speed, or misinterpretation of law. However, in human rights cases, the impact of such errors is what matters. If errors affect the right to fair trial, they cannot be ignored, regardless of intention. Another important point is timing. Ihrda is looking at whether the pace of the trial allowed adequate opportunity for defense. Fair trial standards require that defendants have enough time and access to prepare their case. Any indication that this right was limited raises serious legal questions. The sentencing itself is also being reviewed. Life imprisonment is one of the most severe penalties in law. Under African human rights standards, such a sentence must be supported by a process that is beyond reproach. If the process leading to that sentence is flawed, the punishment becomes legally unstable. Ihrda's findings so far suggest that the combination of procedural issues, judicial decisions, and legal handling may have created a situation where justice was not fully served. This does not mean a conclusion has been finalized. It means the case has crossed the threshold for serious concern. This is why the organization is not stopping at observation. Their role allows them to escalate matters through African legal mechanisms if necessary. These mechanisms exist precisely for situations where national processes are believed to fall short of agreed human rights standards. It is also important to understand that African human rights law emphasizes due process over outcome. Even when states believe they are acting in the interest of security or order, they are still bound by legal limits. Crossing those limits weakens the legitimacy of the entire system. By raising these issues, Ihrda is effectively asking Nigerian authorities to review the case with legal honesty. This is not a demand based on sympathy or politics. It is a demand rooted in law, procedure, and Nigeria's own commitments under African treaties. As these concerns become clearer, pressure naturally builds. Legal pressure, not street pressure. Pressure that comes through letters, filings, and formal engagement. This type of pressure does not fade quickly, because it is documented and institutional. What is unfolding now is a legal evaluation that could redefine how the case is viewed beyond Nigeria. Once errors are formally identified and documented, the conversation moves from defense to correction. That is the stage this case is approaching. This is why this phase of this development matters deeply. It shifts the focus from what people believe happened to what the law shows actually happened. And in human rights law, what the record shows is what ultimately decides the direction of accountability. The focus now moves to what this means for Nigeria as a state and for the office of the president. When a respected African human rights organization reaches this level of concern, the issue is no longer limited to the courtroom. It becomes a matter of national responsibility and regional credibility. Ihrda's position is direct. They believe that once serious legal errors are identified, the duty of a responsible government is to act. Not to argue emotionally. Not to delay. But to correct the process in line with the law. This is the principle that guides human rights practice across Africa. Their attention has now turned to President Bola Tinubu, not as a political figure, but as the head of state. Under African human rights frameworks, executive authorities are expected to respond when judicial processes raise regional legal concerns. This does not mean interfering with the courts. It means using lawful executive powers to ensure justice aligns with legal standards. Ihrda's assessment so far suggests that continuing to hold Nnamdi Kanu under a life sentence issued through a flawed process exposes Nigeria to sustained legal pressure. Such pressure does not end with statements. It often moves into formal petitions, regional hearings, and binding recommendations. The organization's message is that correcting an error strengthens a country, not weakens it. In human rights law, acknowledging mistakes is seen as maturity, not failure. Many African states have faced similar situations and chosen correction over resistance. From a legal standpoint, the call for facilitating release is based on process, not sympathy. If the process that produced the sentence is compromised, then maintaining the outcome becomes legally difficult to defend. This is the core of Ihrda's reasoning. There is also the issue of Nigeria's standing within African legal institutions. Nigeria is a major voice on the continent. It plays leading roles in diplomacy, peacekeeping, and regional leadership. Human rights bodies expect higher compliance from countries with such influence. When a powerful country is seen to ignore regional legal concerns, it sets a troubling example. That is why Ihrda's involvement carries diplomatic weight. Other institutions watch how Nigeria responds, not just what it says. Another factor is the long-term impact. Human rights cases do not expire quietly. Once they enter regional systems, they remain active until addressed. Governments that delay often face repeated scrutiny, increased reporting, and growing international attention. Ihrda's approach suggests that early action could prevent escalation. Addressing the concerns now could limit reputational damage and restore confidence in Nigeria's justice system. Ignoring them risks turning the issue into a permanent legal dispute. The organization has also emphasized that African law is not external pressure. It is law created by African states for African societies. Nigeria helped shape these frameworks. Responding to them is not submission to outsiders. It is honoring commitments freely made. This moment therefore presents a choice. One path leads to engagement, review, and correction. The other leads to resistance, prolonged legal battles, and continued scrutiny. Ihrda's position is that the first path is better for Nigeria. Their findings so far suggest that executive action could play a stabilizing role. This does not require public confrontation. It requires quiet legal steps guided by advice and evidence. In human rights practice, this approach often produces the most durable outcomes. As this process continues, the pressure will not rely on protests or headlines. It will rely on documents, filings, and legal reasoning. That is why it is difficult to dismiss. Law moves slowly, but it moves firmly. For Nigerians watching closely, this phase is critical. It determines whether the case moves toward resolution or deeper regional involvement. The decisions taken now will shape how the issue is remembered and judged in the future. What stands out is that this is no longer about one man alone. It is about how Nigeria responds when African law questions its own legal process. That response will define not just the outcome of this case, but the strength of Nigeria's commitment to justice under the law. What remains clear is that this matter has moved into a decisive phase. With a respected African human rights body actively reviewing the case, the focus is now on institutional response rather than public debate. The findings raised so far place legal responsibility on Nigerian authorities to address the concerns within established African human rights frameworks. This development signals increased regional attention and sustained legal engagement. It also underscores the importance of due process and compliance with commitments Nigeria has made under African treaties. How the state responds will influence not only the direction of this case, but also Nigeria's credibility within continental legal systems. As events continue to unfold, the outcome will depend on legal action, not sentiment. Observers across Africa are watching closely, and future steps taken by relevant authorities will determine whether this issue moves toward resolution or deeper regional review.